Hi, I'm Debbie Moraes, and this is Legal Matters, the program designed to address the critical issues facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics. Most recently, we were talking about child custody, child support. And with us again is our legal counsel from Odette Bizarre Cadero and Grasso law firm in East Providence. Welcome, Jackie Grasso and David Bizarre.
Hello.
We have a fun topic scheduled today, but first, the question that came in from our email listeners, viewers, want to follow up on child custody. And the question is, what happens when a parent doesn't adhere to whatever the terms of child support and visitation are? Are there consequences? And how does the compliant parent take action against the non-compliant? What do they do? What's the process?
If someone's not complying with a court order, the compliant parent has recourse by filing an action in the family court. So in some cases it can be a motion to a judge in contempt. In Rhode Island, in Massachusetts, they call it a complaint for contempt. You want an order of contempt forcing someone to do what they should be doing. In the instance of child visitation, the judge would implement the orders, and if it continues to be a problem, there is a statute in Rhode Island that provides the individual who's not complying can actually lose custody.
Right. The statute says if you're held in contempt twice for interfering with someone's visitation rights, then your custody can be in jeopardy.
And the other issue is if you are found in willful contempt, you risk having sanctions imposed, which means you're going to be paying court costs, you're going to be paying the other attorney legal fees, so what could probably run into several $1,000s. With child support, if you're not paying child support, the courts take that very seriously. If you continue, or an individual continues to be non-compliant and refuses to pay support, it could result in incarceration.
That's interesting. Backing up for a second, you mentioned willful or intent. What does it take? Is it one missed child support payment? Is it one missed visitation? Is it, what's the...
Well, willful means it's intentional. There's actually no defense. If somebody, for instance, can't pay child support because he or she lost her job, there's a defense there.
Yes.
Maybe the person didn't have the money to return to court to modify the child support order. But willful is wanton,
right.
Reckless,
and
intentional.
in that situation that you described where they lost their job, they'd be in technical contempt because the order says they have to pay. But if they didn't have the ability to pay because of a change in job circumstances, the judge isn't going to send someone to jail because they couldn't do something. So if they're not in willful contempt, technical contempt, there's a lot of things that can be done, such as the order can be suspended and whatever was due up to the time it was modified would be held in abeyance until they can afford to pay it. But willful contempt, that's where someone's able to pay and they're willfully disobeying the order of the court. The judge will send them to jail so that they are more willing to comply with the order.
Yeah, usually what the judge says is, pack your toothbrush, you're going for a ride.
It's a free bus trip to Cranston.
Yeah, or in Bristol County, Mass, you go into North Dartmouth. Yeah.
Is there such a thing as a preemptive strike? If you did lose your job before you're in non-compliance, should you instead go to the court proactively and say we need to make a change here because
yeah, you would file a motion to modify as soon as the circumstances have changed. And the federal government has sort of put its nose into child support and those types of things. But one of the things that, as a result of that, happens is you can not modify child support retroactively except to the date you file. So if you do it right away, a court can modify to the date you filed your motion to modify on the change of circumstances, the support order.
That's good news, good information
You need
share.
to do that.
That's good. Well, today, what we're going to be talking about, the rules of engagement, the joys of getting engaged, sort of revisited here. When you think about a wedding proposal, warm, soft, cuddly, romantic, it's wonderful, promising a lifetime of love and binding legal contracts, and that's what we're going to be doing today. So we thought you might want to know a few of the very interesting details that are associated with becoming engaged. So I guess a good place to start with that wonderful event, the man's down on bended knee and here's the ring. Tell us about what happens when that occasion starts. Is it just a nice little gesture?
Well, for the man, the appropriate way of getting engaged would be to do exactly what you said. Get down on one knee.
Yes.
And then you utter the following words. I would like to marry you, and I am giving you this ring in contemplation of marriage. And if we do go through with a marriage, I hope you enjoy it for a lifetime. And if we don't, I'd like it back tomorrow.
Of course, the average person doesn't do that.
Right.
Sort
Yeah.
of takes the bloom off
Does
the
it
rose.
take a little
doesn't
of the romance out of it?
That's what you call your property rights in an engagement
Right.
ring.
You know, as we started talking about this, there are so many legal issues that flow from weddings and engagements and so forth. So starting with the engagement ring, the real question, the serious question is, I gave my girlfriend the ring in contemplation of marriage. I don't use those words when the person comes in usually, but that's what they intended. It wasn't given on a birthday or Valentine's Day or as a gift, Christmas. Am I entitled to it back? And the law in Rhode Island is basically this. If there was an understanding that it wasn't a gift, that it was given as a token of the promise to get married, you have a claim to get it back. If you gave it to your girlfriend on her birthday, on Christmas, those types of times where a gift would normally be given, there could be a presumption that it was a gift and she's entitled to keep it.
And once you give the gift, now you've relinquished your property rights. And
Right.
that's really, when you look at a gift, put aside the engagement ring, any gift, once you've offered the gift, the other person has accepted it and there are no conditions whereby the receipt, which would affect the receipt of the gift, now you've relinquished your rights, your property into the actual item.
Gift giving in Rhode Island and many other states, there's a couple of things that go into it, but it's giving away the present interest to the person to own it and giving actual possession, delivery they call it,
Yeah,
of the
after
gift.
delivery.
So if the gift is delivered, it's a gift. If it's delivered with strings, it's not so much a gift as something giving in exchange for something else.
I mean, I understand that we are in an ever increasingly litigious society, but to imagine that that ring now becomes yet another source of courts and adjudication and all that really do you really have those kinds of court
Those
cases?
exist. There's a simple way of avoiding all this. If people want to spend the time and come in and speak with an attorney, you could draft a prenuptial agreement, and I have put in prenuptial agreements conditions relative to engagement rings. So whereby if the marriage does not last, then the ring goes back to the donor. But then the question is, okay, if you do get married, you have something in a contract will stand. But what happens if the marriage doesn't occur? Okay, because if the marriage doesn't occur, the prenup has no legal effect.
Yes, so that would be a good question is,
Yeah.
I have an agreement, but is the agreement valid?
You could still write up a contract. I mean, a contract is a contract. If it's in writing, you could put something in writing that says if we don't get married, then the ring has to be returned to me, have it signed, witness. Now, that takes the romance out of the entire
I get it.
situation.
Yeah.
Here's
And-
your ring, will you marry me? And by the way, can you sign this paper?
Most people aren't going that far. In fact, Jackie raised the second topic that we could talk about with legal issues surrounding marriage is prenups. A lot of people feel the same way about prenups as about signing something about the engagement ring. If you're going to marry me, marry me. Don't make me sign something. But those prenups can be very important.
I think we probably need to explore that, but I'm still focused on that
Okay.
ring. I have to ask. We have no-fault divorce. Is there such a thing as no fault or any fault when it comes to taking
Engagement?
that engagement ring? Who broke it off? If the guy who gave it is the one who says, I think I've changed my mind, does she get, why shouldn't she
that's a
get
good
to keep
question.
that ring?
That's a good question. And it really comes down to what was intended at the time of the gift or non-gift. If it was a gift, is it a no-fault gift? I mean, in other words, if there was the promise that this is given to you in contemplation of marriage and we don't get married, it's okay for you to keep it if I break it off, but is it okay for you to keep it if you break it off? That usually doesn't play into the equation.
There is some case law in Massachusetts that says if an engagement ring is given, the wedding doesn't occur for whatever reason, if the individual who gave the ring was the cause of the